The innocent signature that creates an indefinite trap. One of the most dangerous documents signed during the immigration process looks like routine paperwork. It is Form I-864, the Federal Affidavit of Support. A person sponsoring a foreign national spouse for lawful permanent residence often signs the form during a hopeful period of the marriage. Many sponsors assume the obligation ends if the marriage ends. That assumption is wrong. Form I-864 is a binding contract with the federal government. The sponsor generally promises to maintain the sponsored immigrant at an income level of at least 125% of the federal poverty guidelines. The Utah Divorce Court can dissolve the marriage, divide property and debt responsibility, and decide state law alimony. But divorce does not itself terminate the federal I-864 obligation. An alimony waiver in a decree may not terminate it. An ordinary prenuptial agreement may not terminate it. Federal law identifies specific terminating events. The obligation may end when the immigrant becomes a United States citizen, receives credit for 40 qualifying hours of work, ceases to be a lawful permanent resident and leaves the United States, obtains a new grant of adjustment or of status in removal proceedings, or dies. The sponsor's death ends future support liability, although accrued claims may remain. Divorce is missing from that list. That means a sponsor may be divorced for years and still face a separate claim to enforce the affidavit of support. The exposure can be severe because courts generally look at the sponsored immigrant's actual income. In many jurisdictions, the immigrant has no ordinary duty to mitigate by seeking employment. If the immigrant does not work or earns less than the required threshold, the sponsor may remain responsible for the difference. This obligation can continue independently of any Utah alimony award and may last for decades. So what should a sponsor do when a divorce begins? First, identify whether an I-864 was signed and whether the obligation remains active. Do not assume the immigration file is irrelevant to the divorce. Second, address the issue expressly. Counsel should determine whether the I-864 claim should be litigated, valued, settled, released, credited, or otherwise incorporated into the overall financial resolution. Third, consider the structure of the settlement. A lump sum payment, property offset, indemnification provision, or carefully drafted credit may help allocate the risk. No clause should be treated as a guaranteed waiver of federal rights, but silence is worse. Fourth, consider claim preclusion. Recent federal authority suggests that in some circumstances, a later enforcement action may be barred when the sponsored immigrant could have asserted the I-864 claim in the divorce. The divorce court was an appropriate court to hear it, and the final judgment broadly resolved or released the parties' financial claims. That argument is fact-specific and not guaranteed, but it makes careful drafting important. The lesson is simple. Form I-864 is not a technicality, and it is not ordinary alimony. It's a federal obligation with its own rules and its own termination events. Anyone signing it should understand the risk before signing. Anyone divorcing after signing it should deal with it directly. The marriage may end, the signature may not.